minutes. That'll still leave us about 30 minutes for questions and conversation. Our first presenter is Josh Blackman of the South Texas College of Law, and the title of his paper presentation is Unprecedented.
Thank you, everyone. How's everyone doing today? First presentation of the conference, leading it off. So, who here is a lawyer by training? Okay. Political scientist. Philosopher. Okay, good. So that just gives me a sense of whether I can say stuff legalese or not. So everyone knows the Affordable Care Act cases, right? The healthcare cases, Obamacare, broccoli. You all heard of these things before? My talk, which is actually somewhat well suited for this conference, focuses on how social movements enable the challenge of the Affordable Care Act. So the Affordable Care Act, as you know, was this huge, massive piece of legislation that was enacted in March of 2010. The purpose of which was to provide health care for almost all Americans in various forms. The most controversial aspect of this law was something called an individual mandate. What was this? You were required to purchase health insurance. If you did not, you paid a penalty, or maybe it was a tax, or maybe it was a penalty. How you characterize it is something of dispute. But you had to pay a fee. When the Affordable Care Act was first enacted, everyone simply assumed that this was constitutional. There wasn't much of a debate. There were a number of scholars who said this was not okay. But for the most part, most scholars said this was okay. Why? As we know, the Constitution gives Congress the power to regulate interstate commerce. And of course, insurance, something that goes across state lines, buying insurance, paying money for it, is interstate commerce. So that was a conventional thinking. There were a number of distinguished academics who advanced a theory about why this was unconstitutional. The theory went something like this. In the past, whenever Congress regulated something, they regulated some form of activity. You bought something, you sold something, you went into a market, you got a job, you grew something. You grew weed on your farm, you grew marijuana on your farm, you did something. This case was different. This was a regulation of inactivity. What does that mean? I decide not to buy health care, I'm not doing anything. You're regulating that inactivity. It was argued that this was unprecedented. What does that mean for something to be unprecedented? It had never been done before. The Supreme Court had never sanctioned such a move before. And with this thinking went, because this law is unprecedented, it's not constitutional. As far as legal arguments go, it isn't the best argument. It didn't have a very good response. The government never had a good response to it, but it wasn't the most powerful argument because it wasn't really governed by precedent. But what made this challenge so unique were the social movements that got behind it. And that's what I want to talk about today. When this law was first enacted, when the law was first being debated in Congress in December of 2009, there were very few objections to the constitutionality of the law. Even in March, when the law passed the House, there were still very few objections. But there were a number of very concerted efforts by a number of prominent legal scholars to push forward this argument this law is unprecedented. And this cry was really adopted by a social movement such as the Tea Party. If we go back to 2010, the Tea Party was a kind of a burgeoning force that had this rededication to the Constitution and this notion that the powers of the federal government were in fact limited and enumerated. And it was with this understanding that many Republican politicians got behind this movement. The same Republican politicians who were silent back in December of 2009 suddenly started taking these constitutional objections very seriously. And moments after the law was signed into law by President Obama on March 23, 2010, lawsuits were filed. It was actually kind of funny. Within 17 minutes after Obama signed the law, a lawsuit was already filed in Florida. 17 minutes elapsed. And I was talking to one of the lawyers in the team, and they said they were actually having problems with electronic filing. They would have done it sooner, but they couldn't do it quickly enough. Virginia filed, I think, about an hour later. It was a literal race to the courthouse because they wanted to get this thing on, and they wanted to get this movement going. And the people who brought the suit realized very early on that this was going to be a long-term case, that this was going to the U.S. Supreme Court. And in order to win, they had to change probably the hearts and minds of the people. This wasn't going to be an argument based purely on legal precedent. They had to do a couple of things. So Jack Balkin has written a lot about how you can take a theory that's off the wall and put it onto the wall. What does that mean? If there's some kind of new, crazy, outlandish legal theory that's off the wall, no one takes seriously, people aren't going to accept it. The idea comes from off the wall to on the wall when people start accepting it. But there's something of a chicken and an egg problem here. If an argument is frivolous, people won't accept it. And if people won't accept an argument, that makes it frivolous. So the challengers had the very unique challenge of simultaneously making the argument non-frivolous and making people accept it. They had to accomplish both of these tasks in a very short span of time. If either of those tasks failed, this would have gone nowhere. You can make up any legal argument if you want, and if people aren't accepting it, it's a frivolous challenge, it won't go anywhere. Or you can make up any argument you want, and if it's frivolous, if people think it's silly, off the wall, it won't go anywhere. But through a very diligent effort through op-eds, blog posts, cable news, talk radio, Tea Party rallies, you were able to have this confluence of thought where people started taking this idea seriously, and at the same time, judges started taking it seriously. When these lawsuits were filed in court, no one gave them a chance. But there were courts in Virginia, in Florida, and elsewhere that started ruling in favor of the challengers. And what made this amazing was when courts ruled this way, it granted legitimacy to the idea. It made it non-frivolous. When you have a court ruling in favor of the challengers, you're ruling against the government, no longer could it be said that these ideas were frivolous, that they made no sense. These were legitimate theories of law that actually had validity. And this effort to change how people think about the Constitution was very, very effective. Okay? And this went all the way up. You had victories in some courts, you had losses in other courts. You know, one court of appeals said that the law was constitutional. Another court of appeals said it was unconstitutional. Then you have a circuit split. Another court of appeals said it was constitutional. And this went all the way up to the Supreme Court. And we all know what happened. Now, a lot of you might think that you know what happened at the Supreme Court, and I might think I do, but really don't. The nature of the Supreme Court's opinion in the Affordable Care Act case is somewhat difficult to understand on several levels. On the one hand, the law survived. In the words of Justice Ginsburg in dissent, the individual mandate survived largely unscathed. But on the other hand, a lot of things changed. So even though the mandate survived, there were still 5 votes cobbled together with Roberts and the block of Scalia, Thomas, Alito, and Kennedy, which said that this expansion of powers under Congress's Commerce powers was unconstitutional. So there was a 5-vote block. Yet, this law still changed. The law still survived. So even though the present signature legislation survived, there is a change in constitutional law. And this change was affected by these social movements with the Tea Party and other constitutionalists who were able to make this change happen. And this might be the most enduring legacy of the NFIB case. It's what Larry Solomon has called the unsettled of our constitutional gestalt. The sense that since the New Deal, our sense of what is constitutional and what the federal government can do has largely been settled. This case has unsettled that. And this case has changed how we feel and think about the Constitution. And this change hasn't been grounded in terms of originalism, that is, this is how the Constitution was understood in 1789. No. In fact, this is some sort of new way of looking at sort of a libertarian challenge to the Constitution, where we effectively concede that the New Deal precedents are set, but we prevent any further ratcheting out of that doctrine. And that's largely what NFIB stood for, this notion that we will not allow the Constitution to go further. We accept what's happened in the past, even though it's probably inconsistent with the Constitution's original understanding. We won't go further. And that really brings me to probably what are the main lessons that we can perhaps draw from this challenge. And I think the lessons can be kind of viewed in terms of the positions people took and how that relates to how they thought things before. So I'm going to look at a couple main groups, and I apologize for using broad labels like liberals and conservatives. I realize these are terms that are very loaded and don't have much significance, but they do help simplify the discussion. So let's talk in terms of liberals. During the Warren court years and the Burke court years, liberals were very much in favor of an activist judiciary. And another term, activist, I think is quite pejorative, but I'll use it here for its simplicity's sake. They were not afraid of courts being counter-majoritarian. They liked it when courts struck down laws they didn't like. They were not afraid of courts recognizing new constitutional rights. But that norm slowly started to erode as the Rehnquist and the Roberts courts kind of picked up the steam. We saw a lot of this with Citizens United, where we suddenly had liberals charging activist judges, and if you weren't paying attention, you might have thought they were being Republicans with these charges for activism. I think this apogee of this activism charges resulted in the NFIB case, where you actually had the President Obama saying it would be unprecedented for the Supreme Court to strike down this law. He used the word unprecedented. He said that this would be an activist court and they shouldn't be doing this. You had other prominent liberals who were actually preemptively attacking the court, saying that if they strike down this law, this will hurt the court's legitimacy. That would be a very, very bad thing if the court does this. So you have this sudden reversal of roles with the liberals. I'll get to conservatives in a second, don't worry. Where they were actually taking on this mantle of restraint, this fealty to judicial minimalism that was so uncharacteristic of what they've stood for the last 30, 40 years. Conservatives, likewise, also had a little bit of a, I call bizarro world, where everything that's fair, what's fair is foul, what's foul is fair. The conservatives who for decades had been railing against these activist judges and saying judges should be minimalist, they should be restrained, they should defer to the democratic process, were all of a sudden urging the Supreme Court to strike down this massive piece of legislation that affected every aspect of the way we live. This was something that was democratically enacted. There was a president who won by a very large mandate. No pun intended, but he won by a very large margin, and he had a mandate to make change. That's what he ran on, and that's what he did. If you go back and look at Obama's speeches during the campaign trail, that's all he talked about, healthcare, healthcare, healthcare. This is what he ran on, and he won, and that's what he wanted to do, and he put his capital behind it. I would say that the traditional conservative response would be, you know what, we don't like this, but we lost the election, and we're not going to let federal judges be counter-majoritarian. That all went out the window very quickly. I think when conservatives start to recognize that by engaging the Constitution, judges can actually reach certain results they might like. Now, I can be less cynical, more cynical. Perhaps they view those results mandated by the Constitution. Perhaps they don't care. I won't make that judgment. But at least they can see that a judge, perhaps second-guessing the judgments of a democratically elected legislature, is a good thing. So they were willing to go after the judges and support them. When the president called the Supreme Court activists, people like Orrin Hatch and Mike Lee and other prominent Republican senators who said, hey, Lamar Smith said, hey, this is not right. Courts should be enforcing the Constitution and should not be worried about what the public thinks about it. They should not be constrained by these majoritarian forces of legitimacy, which is almost a bizarre world. So, you know, we have this almost bizarro world, if you know about Superman, where, you know, liberals were acting like conservatives, conservatives were acting like liberals, and it was just kind of a really curious thing, because it happened so quickly. I flashed through this timeline a little quicker than I would like to, but in the span of 2 years, so much constitutional change happened. And it's very difficult when you're living through this to take stock of what's going on. You don't exactly know what's happening because you're so busy trying to make the arguments. You're so busy trying to win a case, you're not really concerned about what you're doing to get there. I think liberals are guilty about this, as well as conservatives. I think another aspect of what this case revealed is a fissure between conservative judges. For years, when a Republican president was considering a nomination for a federal judge, the litmus test was judicial restraint. Will you be an activist? Will you be a strict constructionist? Again, these are pejorative terms, but I will use them here. Will you be someone who will defer to the democracy? Will you be someone who will not read rights into the Constitution and who will go against me? It's often said that when President Bush was nominating Supreme Court justices, the biggest thing on his mind was the war on terror. Is this someone who will defer to the executive? Is this someone who will defer to the Congress? You know, is this someone who will not be counter-majoritarian? And President Bush nominated John Roberts, and he got exactly what he asked for. John Roberts represents what could be seen as an older type of conservative judge. I don't mean older in the age sense, but kind of a different generation. And this is not even generational by age; it's just a different genre of judges. It's what Randy Barnett has called a judicial conservative. That these are judges who are willing to be more restrained, have more fealty to the democratic process, and be less willing to enforce the Constitution. If you look at John Roberts' opinion, he effectively did jurisprudential gymnastics to get to the outcome, where he had to do this bizarre saving construction to save a law that by his own interpretation should not have been saved. The newer generation, and again I don't mean new by age, but just a different genre, is what Barnett has called a constitutional conservative. These are conservative judges who are willing to enforce the Constitution and be a little bit more engaged and active, even if it means going against the democratic process. Perhaps Clarence Thomas is a good example of this, but also probably Justice Alito as well. So I think what this case recognizes is that in future debates over the Supreme Court nominations on the Republican side, judges are going to have to actually be attuned to this. It won't be, is this guy an activist or a constructionist anymore? I think that's gone. I think the question will be, how will this person engage the Constitution? Will he consider rights created by the Constitution as important, or will he just simply defer to the democratic process? I think this will be a very important fissure coming forward. The last group I want to focus on is actually libertarians. Many of you might not think much of libertarians, either their philosophy or their contribution to society, but this challenge began and started by libertarians. That's where this began. When this law first started, conservatives were largely on the outside. They were opposed to this because things like the Cornhusker kickback and Louisiana Purchase, these other deals to buy votes. Conservatives were opposed to Medicare funding and various policy grounds. You might not know this, but the individual mandate was originally a Republican idea. It was actually created in the 90s as an opposition to Hillary Care, that rather than mandating social health care, we have this tax on people who don't have a health insurance. So we actually have libertarians who are very much involved with this, and I will give a lot of the credit to Randy Barnett, who's at Georgetown, and was the, as the New York Times called him, the intellectual godfather of this challenge. And Barnett did wonders to move this advance forward. But there were a number of decisions made that I think required more reflection. One of which is the choice not to advance an originalist argument in this case. Now, Barnett and others have conceded that under the original understanding of the Constitution, the individual mandate would be unconstitutional. But that argument will be a non-starter. They turn to kind of a precedential argument saying, even assuming that all these other cases like Wickard and Raich are correct, which they do not concede, this is still unconstitutional. And I think that speaks something about originalism. I call it the originalist dog that didn't bark. If in the most important constitutional law case in 20, 30, 40, 50 years, originalism can't be used, what's its vitality? Does it only work when you deal with a clean slate? What happens when you have these entrenched precedents like Wickard that are 40, 50, 60, 70 years old and aren't going anywhere? So I think ultimately this case, this strategy reflects a shift saying, hey, we realize these cases are not going anywhere, so let's kind of make like an originalism light, so to speak, where we will work on originalism where it's at kind of the, penumbras, or so to speak, the crust where other things aren't so well entrenched, but when you have this core precedent like Wickard, we'll just concede it's correct. And this actually reflects Barnett's litigation strategy in Gonzales v. Raich, which you argued years ago. I think it also reflects a change in how libertarians approach popular constitutionalism. They realize that people, through the Tea Party and other elements, like talking about the Constitution. They like thinking about it. They like saying, what does a Constitution mean? How was it understood in 1791? What are our constitutional rights? And by tapping into it, they were able to take this quasi-frivolous argument from off the wall to onto the wall in very record time. They were able to make it so that the challenge went somewhere, that judges thought that this is something we can buy. That chicken and the egg problem I described, where an argument's frivolous on people unless people accept it, and unless people accept it, it's frivolous. By moving this social movement behind and getting Republicans and Tea Party people behind it, we were able to accomplish both things in record time. I think that's quite amazing. And I think really the last thing, and I touched on this before, is how this challenge affects the Constitution. What does it mean now? Are the New Deal precedents settled? Is this what Larry Summers referred to an unsettled Constitution gestalt, where the nature of how we view these New Deal precedents is no longer set in stone? What's the next case? We don't know. We don't know what the next case is going to be. If you had asked me 3 years ago or 4 years ago, can Congress mandate people buy health insurance? My answer would have been, of course. Now we know that might not be the case. The nature of constitutional arguments is somewhat on a case-by-case basis. And when you make these strategic decisions about how to litigate the NFIB case, it sets precedents, no pun intended, for the next unprecedented case. You are effectively limiting or constraining or narrowing how you challenge cases based on what you did before. And by not advancing an originalist challenge, you make it acceptable in the future not to do it again. By advancing an argument that accepts Wickard and Raich as precedent, you're saying, okay, we get it, these are precedents, we'll go on from there. So I think the enduring legacy of the NFIB case is how this impacts future constitutional challenges to laws we can't yet predict. And I think that in this context of this conference on social movements, we'll realize how the people have become such an important element in taking this argument about an unprecedented law from a mere law review article or an op-ed or a blog post all the way to 5 votes in the United States Supreme Court. And I thank you very much.
We'll do the questions after.
Okay, that's fine.
Everybody present. Jared, did you want to use the podium or come up here? Or?
Yeah, I'll speak on the podium.
Podium? Great. Okay. Josh, if you could.
Yeah. I'm going to set them up here.
Great. Okay, our next